Most of us assume that when we pass away, everything we own will just naturally slide right over to the people we love. But if you die without a valid will in Michigan, you fall under a legal status known as dying intestate. Dying intestate means the state of Michigan's default succession laws activate. The government steps in and takes complete control over how your legacy is divided. By delaying your estate plan, you grant the government the power to dictate your family's future. Without a will, Michigan law forces an estate split between your spouse and parents. Unmarried partners receive absolutely nothing, since Michigan ignores common law marriage. Finally, the flow bypasses stepchildren entirely, cutting them out unless legally adopted. And if you have minor children, dying without a will means a judge, who has never met your family, will decide who gets to raise them. You can override this rigid default system yourself, without spending thousands of dollars on a lawyer. The state's formula blindly prioritizes strict legal bloodlines over your actual family dynamics, creating unintended chaos and conflict for the people left behind. A Michigan last will and testament is your manual override tool. It puts you in direct control of asset distribution, executor selection, and naming guardians for your children. To create a legally valid will in Michigan, you simply need to meet two baseline requirements. You must be at least 18 years old and of sound mind. The document has to be in writing, and you have to sign it in the physical presence of two witnesses, who also sign the document. You also want to include something called a self-proving affidavit. This is a notarized statement attached to your will. It allows the probate court to validate the document immediately upon your death, sparing your family from having to track down those original two witnesses years or decades later. A properly executed will acts as a legally binding instruction manual, deleting the state's default rules and replacing them entirely with your own design. There is a massive misconception in estate planning. Having a valid will does not mean your family avoids the probate court system. A will just gives the judge your instructions. The legal process of actually settling the estate still takes 9 to 18 months and requires hundreds of dollars in court filing fees. This court friction becomes a massive bottleneck for real estate. Your family home gets tied up in the system, preventing it from being sold or transferred while you wait out the long probate timeline. To solve this specific real estate problem, you need a specialized gap filler known as a Michigan Ladybird deed. Looking at this timeline, you can see how the Ladybird deed works in tandem with the will. Instead of the house getting stuck in a 9 to 18-month probate block, the deed bypasses the bottleneck entirely, transferring property to beneficiaries the moment you pass away. While your will flawlessly handles your personal belongings and the guardianship of your children, pairing it with a Ladybird deed ensures your most valuable asset is completely protected from court friction. Estate planning serves as essential administrative hygiene for every adult, regardless of whether you have a complex business or a single bank account. Deploying this specific combination of a will and a Ladybird deed eliminates ambiguity, drastically reducing the chances that your family will dispute over assets. You keep thousands of dollars out of lawyers' hands and save your beneficiaries months of stressful bureaucratic delays. Finalizing these documents secures your family's future through one decisive act of protection. You can establish this baseline of protection from your own living room using the Noble Notary Signing Services Michigan Last Will and Testament template. For just $14.95, you get a template drafted specifically to comply with Michigan state laws. It's designed for ease of use. The instant download opens across Microsoft Word, PDF viewers, or Google Docs, and it already includes the crucial self-proving affidavit. Click the link in the video description to purchase and immediately download the template package. Opt out of the state's default system, download your template, and take permanent control of your legacy today.